Welcome back to Layman's Law School, where two hillbilly lawyers demystify the law, talk about the issues of the day, and have a drink or two on a Friday.
Got to.
Welcome back, Reid.
Hard week again.
Yeah.
We did excellent work again, and we're here to, like you say, try to. You'll give the expertise, and I'll kind of give the hillbilly version of it. How about that?
So Johnny Depp.
All right.
So my wife is gonna shoot me unless we talk about Johnny Depp at some point. Okay. Johnny Depp has filed a defamation lawsuit against Amber Heard. Amber Heard is his ex-wife, who basically did an op-ed piece through the Washington Post.
Well, that's debatable, Chace. You're assuming facts, not in evidence.
No, she's admitted.
She
actually admitted
it on the stand, but that was part of the trial. But yeah.
Which was funny because her lawyers denied it.
Yeah.
That he had to prove that. She admitted it on the stand. So she helped out the plaintiff in that in that particular case. She filed a counterclaim against Johnny Depp. But let's just start out with some of the elements in layman's terms for defamation.
So defamation happens a lot. It happens a lot in everyday society. But the problem is the damages aren't there. So defamation is essentially harming someone's career, someone's income, blah, blah, blah. But the problem
through an untrue statement.
Through an untrue statement. Correct. Yes. But the problem is damages. So if Chace calls me, a son of a bitch, and everybody believes I'm a son of a bitch, I mean, it's probably not going to hurt my career that much, Yeah, so, but if I lost out on
this
a bunch of cases, then I got some issues. And so in their situation, you're talking about big money, right?
Yep.
You're talking about big money.
Yeah.
And you're talking about millions on millions on millions of dollars that, I'm not the juror, but potentially he could have gotten without her having that false information. That's his claim. And so when you talk about defamation, I hear it a lot. People come in and talk about it a lot, libel and defamation. It's just the problem with it is, in
most
99% of the cases, is that you can't show the damage.
Right.
So in this case, it's an extreme example, but it works well with the law and to show people like, This is a viable defamation. This is a viable defamation. Now, he might be wrong, he might be right, but you're talking about the damages are enough to say, hey, we got to bring this to court. If you lose $100, it's probably not worth going to court for.
Sure.
If you lose, if you're a yard man and you lose one customer because this guy said some untrue things,
right?
You're gonna spend
your damages for that
$5,000 in court, and you're gonna end up getting $2,000.
Well, how much could you have earned with that one customer?
Right.
Yeah, we're gonna start to hit pretty hard on your on this podcast is the basic idea of negligence, some of the elements that are required. When we talk about elements, we're talking about like the components that are required in order to make a claim.
So,
and so we have
even break it down.
Duty,
so
breach, causation, damages.
Right. And now, go ahead, Chace, like you said, you listed 4 right there.
Right. You have a duty not to go around basically stating false information about people that are gonna, is gonna harm their reputation.
Right.
You breached it by producing an op-ed, if it's false, and then if that op-ed actually caused or helped to cause, contributed to causing you losing lucrative contracts, then you have a valid claim for defamation. So
the problem, not with this case, but the problem in general is that I always call it the 3-pronged stool. Now this one has 4, but generally in most cases there's 3 prongs. If you have a stool that has 3 prongs, and one of them might be the strongest prong that you could ever have in the world, right? But if it doesn't have 3 prongs, the stool falls
over. Yep.
And so that's why this case is so interesting, is because you have all the prongs. Generally, you have people come in and say, well, this cost me X, Y, and Z.
Or this was false.
Or this was false, whatever it is.
They said it.
But you're missing one of the prongs, and it just doesn't work.
That's right.
And we hear that all the time. That goes back to, I could have died, So it's the same type of situation. But this one's very interesting to me because everything's there.
Sure.
Now, I don't know what the jury's going to decide. I don't know. But all the elements are there.
That's right.
And I think people lose, at least the common people that I talk to in the office, they want to focus on one thing. It might be damages, it might be negligence,
whether it's true or not.
Right.
Yeah, that's what most people are upset or talking about with them. Yeah,
and it's hey, I want to do this because I feel wronged. I feel, it's principle.
Sure.
Principle will make a lawyer go bankrupt.
Yeah.
You have to have all the prongs.
Unless you're Johnny Depp.
Unless you're Johnny Depp.
Yeah,
Johnny Depp, he can do that.
He can pay some legal bills.
Yeah.
Yeah.
But that's I think that is a not misconception, but something that's not understood in the general public is that you have to meet every point.
That's right.
In order for it to make sense. One point is like crazy strong.
Yeah.
Like at 1,000%, that doesn't cover up the other factors.
It's like, for instance, if you can prove that it's false and prove that they said it, okay, that they knew it was false when they made it, right? You can prove all that. And that you lost you lost a contract on this date, right? But you can't prove that person who denied you the contract knew about that statement.
Right.
Okay. Right. You lack causation. So you have to have duty, breach, causation, and then the damages. So in that situation, unless you can prove that person knew and that person made that decision based on the false information. So for instance, like in this Johnny Depp trial, one of the people that testified was Johnny Depp's business manager and agent.
Right.
And when it came to the Pirates of the Caribbean,
was it 5 or something?
It was 6, one. Let's just say the Pirates of the Caribbean franchise, and the what was it? The Harry Potter. What's her name? The author, D'Angelo, J.K. Rowling.
J.K. Rowling. Yep.
That it was the Fantastic Beasts.
Right.
He had that franchise as well, and he lost both of those contracts according to his agent, based on the accusations that were made by Amber Heard and that were sort of chronicled in this particular article.
The testimony essentially was like, in the industry, he was a leopard. He couldn't get a job.
Couldn't be touched.
He couldn't be touched because it was in the middle of the Me Too movement.
That's right.
And she's making allegations against him, and anything he says, it doesn't matter.
Right.
Because he's already lost it. And now once you lose that opportunity, and in different jobs, they're just
they can come back.
They come back. Yeah. But these are gone.
Forever.
These are gone forever.
Absolutely. Another actor's already played that role, and so it's a real problem. But it has actually helped us to establish an opportunity to talk about the importance of having experienced trial lawyers. And so I want to talk about, all right, so there's a distinct difference that lay people have recognized between the trial lawyers on the side of Amber Heard and the trial lawyers on the side of Johnny Depp. And I have been impressed so far very much with Johnny Depp's attorneys. And for instance, like the fact that they chose Virginia. All right, Virginia is very unique in that they actually televise their trials.
Right.
Okay. So they don't have any restrictions on that. Okay.
When it's televised, everybody. So when you see, and Amber Heard lawyers are not lying, right?
No,
they're not lying. They are saying what their client has told them,
and they're presenting their client's best case, and that's their job.
But sometimes they don't know that it's wrong because all they know is what the client's told them.
Exactly. But what I want to highlight here is the importance of having a good lawyer to start out with. So we're talking about guys that analyze this, and what they recognize is that Virginia was a state that televised this. They looked at what their clients,
one smart decision.
Their client's goal was to clear his name. Number one,
and
who
the
money
the client is.
That's right.
That's important.
Right, and they wanted to clear his name. Okay, and they don't have anti-SLAPP laws. SLAPP laws. Or a SLAPP lawsuit is basically a lawsuit where a person that's rich can basically start a lawsuit just to shut you up. Right? They can sue you into submission. Just because you can't hire somebody to represent you for free, they can afford to hire you to sue you into being quiet. If in Virginia didn't have any of those anti-SLAPP laws, and so that helps them to if in the event it's shown that Amber's successful in defending this case, that it's not going to have huge detrimental effects to Johnny. And so we had a situation where, like, all of the goals for Johnny are met in just actually filing the lawsuit, that he gets to present his side, that the public gets to hear it, that he's not exposed to overburdensome sort of like sort of anti-slap laws that could come in and hurt him if a jury goes the other way. Sure. And they did it in a very sort of ingenious way in that the Washington Post servers from which the publication of the op-ed were issued were contained in Virginia. That's the only basis for it being housed there. And so venue, in many cases, is something a plaintiff can select, and they selected it very well. And the fact that a firm took that much care and time in selecting an actual venue kind of shows you the level of preparation that they started out the case with, and that's a good indicator.
And this is going back to the beginning of the podcast. This is the difference between federal and state law. Federal gives you the umbrella, then state law has different actions. So they chose correctly because even if they lose, when I say they, I mean Johnny Depp's crew. Even if they lose, they've still won. Because they don't really care about. She's not going to pay the money.
No.
She's not. She's going to.
Not likely.
I don't care what they award. She's going to file bankruptcy and have it in some LLC.
Right.
He's not going to see a dime of it. But he has done Johnny Depp has done what he wanted to do. Which is to show the general population. That this girl's not truthful.
I might like to play the guitar. I might be a little bit strange. I might like to do drugs on occasion or whatever. But I have never hurt anybody in my life. And that's what he wanted to do. That's what his lawyers, and that's what people need to understand about the law, is that lawyers are like captains of a ship. Okay? You tell us where you want to go, we'll drive the ship, but you're in control of where it goes. And in this instance, that's what he's doing.
Essentially, what's your
goal?
We ask this all the time.
Yeah, what's your goal?
What's your true outcome?
Yeah, what's your goal?
What do you want? Yeah. Now, if you want retribution, if you whatever it is, so you got to have the goal before you know how to get there. Now, Chace, I saw one clip that I want to ask you about. Amber Heard was on the stand, and she mentioned something about Kate Moss, right? And the Johnny Depp's attorneys were really excited about it. And Amber Heard's attorney was like very upset about it.
Yes.
Why is that?
Okay. So what Amber Heard did was she brought up a past event that basically showed, or was an attempt to show, that Johnny had a particular type of character. And typically character evidence of that nature, where you've acted in conformity with what you're alleging, when I say acted within conformity, is like if someone says, hey, he's aggressive and he beat me, and you point to other events in their life before that, typically that is inadmissible in court, right? And
could not be brought in.
It could not be brought in
at all.
Right.
Can't mention it. Can't talk about it.
But what she did is what we would commonly refer to as opening the door. And
so let me stop you.
Yeah, sure.
So Johnny Depp's people would want to bring this stuff in.
Yes.
And it would not be allowed in unless
she brought it up. So Amber Heard has allegedly attacked her former lovers in other situations. In situations like this, the fact that she brought this up and she opened up past character evidence, well, now it means that it can be brought up against her. So all the past accusations about her being actually violent can be brought up, and Johnny Depp's past accusations can now be brought up, even ones in which the witnesses, like Kate Moss, have said never happened. And so what I anticipate is that Johnny Depp's team is going to bring up Kate Moss, and Kate Moss is going to say, that never happened. That was alleged. It was a BS thing brought up by somebody. Yeah, exactly. And so that's going to undermine the credibility of Heard. And this is all about credibility, because there's nobody that was there except those two.
And they're going to get to bring in, and I don't know the history, but I know she has history of some kind of abuse with other relationships, and they're going to be able to bring all that in. All that stuff was excluded until she said those words.
That's right, and that's why you saw the fist pump.
Yeah. and you also saw, I can't remember her name, but the lady attorney for Amber Heard just shake her head.
Yeah, it's pretty rough.
She knew.
Yeah,
and it's about to be cross on Amber Heard. And it's all coming.
Yeah, it's gonna be a little rough. That brings me to another point, because there have been some missteps by Amber Heard's attorneys, and it's
now. Let me say this. So, I'm agreeing with you.
Okay,
but I want to take up for them a little bit, right? A little bit,
by all means.
All right. So, and you can clarify it. He's being the guy attorney for Amber Heard,
Mr. Rottenborn.
Okay, I don't know the name. I don't remember names. But he objected to an answer that Johnny Depp
that he elicited
questioned. But everybody's picking on him, and I get that. I pick on him too. But that's not completely wrong.
No.
Right? Now, how would you handle that as a trial? Now, he did it wrong as a trial attorney, but how would you handle that as a trial attorney?
First of all, I would not have asked a question that I could foresee the person would have basically talked about something else somebody said. I would have framed my question a little bit differently, number one. Number two, as soon as I heard the words he said or somebody told me, I would have asked the judge in that point, said, Your Honor, I would have interrupted him.
Right.
And I would have said, I would have controlled the witness, and I would have said, Your Honor, I wanted you to instruct the witness not to talk about what other people told him.
Right.
Okay.
So, and he was right on what he said about hearsay.
It was hearsay.
It made him look like a fool that he objected to his own question. But
that's right.
Yeah. He was right on what he said.
That's right.
Just not the way he did it.
Right. And unfortunately, that's a hallmark that we're seeing quite a bit, in that we have lawyers that don't have as much experience. We try to go to trial as much as we possibly can to actually get this experience. Hiring out of the prosecutor's office, public defender's office is great, just because a lot of those cases go to trial. We can only go to trial if our clients allow. And so having that experience to know exactly what to do, and in the moment, while you're nervous,
he panicked.
Yeah, he panicked a little bit, but he wanted to keep that information out. But what it had the effect of doing was helping to create the impression that what he said was important, and so the jury heard that, and so that was a misstep,
big misstep.
Yeah, and so this is why a case like this is not the case to cut your teeth on,
right? And
you need to be well versed, ready to go, experienced when you have a case like this. So, but at the same time, I mean, like I said, these guys they have a difficult case. They're presenting a difficult case. They have apparently a difficult client. They have difficult facts.
Right.
And so, I mean, my heart is with them.
I
mean, it really
they have a very, very difficult job.
Yeah, and so as much as I criticize them, I just want to. I am going to criticize some of the things that they do.
Sure.
But I'm using it to sort of teach as much as I can. There was a particular witness, okay, that through the questioning, okay, this is Johnny Depp's, an artist that Johnny Depp sort of patronized. His name, I think his name's Isaac. I can't remember his last name. He provided him an apartment.
Right.
Okay. He said, hey, I just want you to paint, okay, because I like your artwork. And paid for his living expenses for years. Right. And she asked him a series of questions. And she had established thoroughly that this guy was in Johnny Depp's pocket.
Right.
Right. But she made the ultimate mistake, okay, of asking the final question. All right. And when I say the final question, she went too far. She asked him to confirm the argument that she should have made at closing.
Right.
Okay. And this is a cautionary tale for all you attorneys out there. If your main point, when you write down your goals for a cross-examination,
you better
to start out with him, I would have said, this is his friend. He is angry at Amber because Amber hurt his friend and is trying to hurt his friend, and he's putting him in a financial strain. Who is the financial
the beneficiary?
The beneficiary of it? Me, right? I want to establish that, right?
And essentially what you're doing is making that witness lose credibility.
Exactly. You can't believe this person because they are biased terribly.
And they might not be trying to lie.
That's right.
But they just, like, if I'm testifying for you, I'm going to be biased.
Right.
We're friends.
Right.
I'm just going to be biased. I can't help it.
Yeah. And I want to play for you, if I can, D'Angelo. You play that clip of Isaac, Johnny Depp's friend and the painter that was living in the studio, to show you sort of what happens when you overstep and ask the sort of final question.
He's given you $100,000. He's put you in that nice. I'm sorry. I didn't hear the whole question. Can you say it again?
You were rent-free in penthouses for a number of years, and now you've been rent-free ever since in Sweetser?
What's important is to recognize that this guy's been on the stand for about an hour, and he's been telling jokes. The jury's laughing. Right. The gallery's laughing.
He's made friends with them.
Absolutely. You know? And so people like this guy, right? Yep. And so you have to pay attention to that as an attorney. And she's not doing that.
No, she's when the jury likes somebody and you're coming at them, you better be careful.
That's a nice friend.
Yeah. Okay. And I think you testified already. You're pretty angry with Ms. Heard, right?
When?
I wrote it down that you.
About the phony pictures that would.
All right.
Oh, that's rough.
So there's the question, right?
Wow.
All right. So he's about to do it to her. He's about to give her exactly what she asked for, right? But that's the argument. The argument is that he's angry with her.
Right.
Okay. That is what you make. That's the argument you make in closing.
Right.
Okay. So she's established that he's, beholden to Johnny.
Sure.
That he likes Johnny. Sure. That they're friends. Yep. That he owes him. But what he's about to do to her, because she gave him the opportunity by asking, "Aren't you mad at him?"
Right.
Right.
And that's a dumb question.
Well,
nobody. It is. It's a bad question.
It's because it can be inferred.
You can say and it's subjective. That's a bad question.
Yep.
That were taken and put in tabloids, and about the fake narrative and the way she's trying to got a fraudulent DV claim.
Yeah. So exactly.
That's bad.
Yeah. He's making a closing argument for her.
Well,
right? For him.
The problem is that the attorney, you have to allow the witness to explain their answer. And she made a claim, essentially, even though she was saying, "Aren't you?" She was trying to lead him into something, and he was smart enough to go, "Well, I'm going to tell you why."
Exactly.
And that's... that's death. That's death.
Right. And so here's the thing is, I bet you she had that question written down on a checklist. Right. But everything that occurred before this, okay, if you watch this, all right, he is thoughtful, he is careful, he is charming.
Right.
And she should have anticipated this is not the witness.
You can't ask that question.
Exactly, that I give this opportunity to. And so you have to, in a lot of situations, shoot from the hip, make a decision on the fly. And if I have a jury, a person that's this favorable to Johnny Depp, I establish, one, that he is beholden to Johnny Depp.
That's it.
Financially beholden to him. She hurt his finances.
That's it.
And that's it. And get him off of there.
You cannot do that. That's a terrible mistake.
Yeah.
When you open the door like that to someone the jury already likes, and so what the Amber Heard attorney is trying to do is make this guy lose credibility.
Yeah.
And she just made him gain credibility.
Absolutely.
She did the exact opposite. You can't ask that question. That's terrible.
Yeah, and the worst part is he's not done.
To extort and blackmail a man, that kind of got me
pretty
frustrated, confused, angry, upset. Yes. Which is why I said the best thing for us to do is not to talk to each other.
He just improved his credibility by the way he answered, not what he said, but the calmness. He wasn't angry because what the Amber Heard attorney wants is outrage.
Yeah,
hell yeah, I don't like this.
Screw that guy.
Yeah, screw
her.
Woman.
Screw her.
Yeah. He goes, no, I'm not. His body language,
because this ain't right.
Right, but his body language is, I'm not mad right now. I'm mad at what caused me to be here. And I'm speaking very calmly. I'm speaking very intelligently. And I'm telling you what happened.
Yeah.
And you just lost everything as the Amber Heard attorney. That was a terrible question.
Yeah. Well, unfortunately, she doubles down.
Oh, we got more?
Yeah.
Oh, God.
Was it fair to say you're still angry with her?
Oh, you know something? It's 6 years.
But we just heard you give your version.
Am I angry anymore? I'm not, what I am is tired.
Okay. So, all right, boom. So he might as well be a jury member there. Okay. So is he angry? The jury's not angry. He's not angry anymore.
The jury doesn't want to be there.
They don't want to. Exactly. And so when he said that, so like now all of her momentum that she built with, hey, this person has it out for her, is gone. Is gone. He's like, this is 6 years. I've moved on.
Right.
But this, and
y'all are dragging me. Y'all are dragging me back in here.
But watch what he does to her next.
Man,
it gets worse.
Yeah, all right.
Yeah. Like I said, this might well be the closing.
And I want this all to end. Her to go heal, him to go heal. So many people have been affected by this malicious lie that she started and she created.
Wow.
Boom.
Wow.
Man.
When you show sympathy
for
the person that you're, essentially he's being accused of being one-sided and taking out against this. I have motive to hurt this person.
Sure.
And when you have sympathy for that person,
I want her to heal.
I want her to be
Move
fine
on.
too. I want everybody. That is cement.
Yeah.
That is not wishy-washy.
Yeah, jury's going to remember this guy.
Oh, my goodness.
Yeah.
That is not great.
I can't even paint anymore. I've stopped painting for the last who knows how many years, and that's affected by stuff. I'm not angry at anybody.
There's nothing more important than being sort of real on the stand for a witness, right? And he's gotten to a point where he's been on the stand for a long time. He's been charming. He's been kind. He's been a lot of things.
And you can fake it on the stand for a while, but you just get worn out, and then you just are yourself.
Right.
And the jury's just seeing this is who this guy is.
Right.
Man.
And a lot of times you'll get a witness on the stand, and you'll ask them inane questions. Where you live, how long you been there, because you can see they're not being themselves.
Right.
And you're trying, and please, if you're on a jury that I'm on and I'm asking questions about where they live and how long they live there and where they work, and they don't have anything to do with what we're talking about, that person is terribly, terribly nervous. They're not comfortable on the stand, and they don't know that they're not coming across as genuine.
Just trying to get them to talk.
Right. So I'm asking them questions they know, so I'm getting them comfortable or whatever.
Right.
This guy is comfortable,
Right.
has been comfortable, is making jokes, making friends up there, right? And now he's getting to the point where he is sick of answering these questions. Right, exactly. And he lets her have it.
I want the best for her to take her responsibility, heal, and move on. And for Johnny, his family has been completely wrecked.
So he starts talking about his family, and that's pulling in sympathy for Johnny. Now watch him here. Go ahead and play it again now, and watch him. He gets emotional here.
It's not fair. It's not right what she did and what happened.
Okay, so that's it.
That's it.
That's
over.
That is a grown man that's seen a lot.
Well, and
he is so emotionally moved.
He comes across as a tough guy too.
Yeah,
like a guy that's.
Yeah,
I know he's an artist and all that, but he's got the New York accent, the tough guy,
and he's up there in this tough position,
right?
Right,
he's just
telling it like it is.
Oh man, that's
right, and he's getting emotional about what has happened to his friend and what he's seen it do to his family and stuff like that.
But it came across that he's friends with her.
Yeah, that he wants the best for her.
He wants to be friends with her. He was friends with her.
Mm-hmm.
This is a bad situation, and he still wants the best for her.
Right.
And all I'm telling you is the truth.
Yeah.
That's what I see.
Yeah, and so this is a cautionary tale for all of those attorneys out there that ask the ultimate question, and I would advise you to go on YouTube because it's out there. Irvin Younger, his 10 Commandments for cross-examination. Do not ask the final question. Right. Use that for summation. In this situation, the woman asked the final question twice. Okay, she wanted to make the point that he had a bone to pick with her, that he's biased, and that's why you can't believe him.
Right.
And she asked him that question, and he took that bone and beat her over the head with it. And
gave him the opportunity to not say yes or no.
Yeah.
Gave him the opportunity to say all these other things that weren't asked. All these other questions that weren't asked. Oh, that's brutal. That's a bad mistake by the Amber Heard defense.
Yeah, and like I said, my heart goes out to them. I know they have a difficult case to defend, but
you can't ask that question right there.
No,
you just can't.
No, that's a difficult one. If you are tuning into the Amber Heard trials and you want to hear sort of more about that, please sort of leave your comments below, and we will address some of your questions that you have about the trial. If you want us to analyze a particular part of the questioning or a particular witness, be happy to do that too. We've been following the trial and continue to do that as it starts up again next week.
There's a lot of questions that people will say, well, why would they ask that? Or why would they say, like the objection thing? There are reasons. And you know, people always pick on attorneys about asking dumb questions, but sometimes you have to. Sometimes you have to. So we can certainly explain why that's asked. It might not have worked, but you can say, well, you know, this is the reason they asked that.
Sure. Well, with that,
Good Friday, buddy.
Yeah, we look forward to Amber Heard's testimony starting next week.
That one's going to be exciting.
This is the cross-examination.
She's going to get destroyed on the cross.
I can just
tell you, it's going to be rough.
Yeah. Well,
I look forward to that next podcast on the cross, because that's going to be explosive for attorneys.
Yeah, absolutely.
For attorneys.
Absolutely.
So cheers, brother.
Happy Friday, brother.
Happy Friday.